Alcohol-related car accidents, what you should know. If you have been involved in a car accident and you think it was alcohol-related, you may want to take your claim to court. Alternatively, you may wish to hire a lawyer to help uncover evidence or to speak to the other driver's insurance company on your behalf. Below you will find links to articles that may help you with all of your queries and questions. Had a DUI-related accident and facing a lawsuit? If you had been drinking alcohol at the time of your car accident, you may find the whole situation incredibly stressful. If you have pleaded guilty to driving while intoxicated or driving under the influence, or you have been convicted of these things, anyone who sustained injuries in the accident is likely to file a lawsuit against you. Lawsuits can be quite confusing and complaint, especially if you don't have very much knowledge of how they work. A lawsuit can be filed within days of the car accident and it may come as a surprise to you. In some parts of the United States, a lawsuit can be filed up to 5 years after the car accident. If you are taken to court because it's believed that you caused an accident, you may want to know what you should expect. Can a bar be sued for selling alcohol to a drunk driver? A bar, a restaurant, or a liquor store could be found liable if they have sold an alcoholic beverage to an intoxicated customer. Many state legislatures have passed a version of what is known as a dram shop law. This type of law is known as a dram shop law because alcohol was previously sold in drams, which is a unit of measure. The argument in this type of case usually revolves around arguing that the alcohol did not cause the plaintiffs, the victims, injuries. Social host liability rules in California dram shops. Every single state has their own rules for any potential lawsuit that has been brought against social hosts of vendors. These rules relate to those who have served alcohol to someone who, when involved in an accident, has caused physical harm to themselves or to someone else. What is California's law? Before we take a look at California's dram shop laws, we need to understand what the majority of personal injury cases involve. These cases typically involve the injured person, and the person or the company who is alleged to have caused the injuries. In a social host or dram shop case, the injured party will be seeking damages from the host or vendor who gave the alcohol to the person who caused the accident. Alcohol-related accidents, social host liability rules and dram shop laws in Texas. If you are injured by someone who is intoxicated, you have the opportunity to bring a personal injury claim against the person who injured you. However, you might be able to bring a claim against the third party, such as the restaurant or bar who sold the alcohol to that individual. Claims such as these are known as dram shop claims. This article, however, concentrates on Texas's dram shop laws and the rules that affect anyone who provides alcohol at a range of events such as parties and weddings, etc. Alcohol-related accidents, social host liability rules and dram shop laws in Ohio. In Ohio, an injured person can bring about a civil injury lawsuit if a business or social host served alcohol to someone who caused a car accident due to being intoxicated. However, Ohio only lets an injured party file a claim under very specific circumstances. Ohio's dram shop law. Section 4399.18 of Ohio's dram shop law lets an injured person file a lawsuit if the injuries they sustained occurred on the vendors, the person who served the alcohol, property, and the injuries were caused by their negligence. They can also file a lawsuit if the injuries occurred elsewhere but the vendor sold alcohol to someone who was clearly intoxicated, or they were under the age of 21. Alcohol-related accidents, social host liability rules and dram shop laws in Florida. Every state has specific laws that allow injured people to seek compensation when they have been involved in a car accident or any other type of accident that was caused by someone else. When there is alcohol involved in the accident, there are laws in a few states that let the injured person seek compensation from a business or person who is known in the case as a third party. This third party would have had to provide alcohol to the individual who caused the accident. Claims filed against a business as known as dram shop laws. Florida's dram shop law. Section 768.125 of Florida's statutes specifically details the dram shop law. It says that if someone provided alcohol willfully to someone under the age of 21 or they provided alcohol to someone who has an alcohol addiction, they will be found liable for the injuries that we caused by the addicted person or the minor. The state of Florida will not hold a business or individual responsible if they have served alcohol to someone who is clearly intoxicated. Alcohol-related accidents, social host liability rules and dram shop laws in New York. In New York, as in every state, there are specific laws that allow injured people to seek compensation when they have been involved in a car accident that was caused by someone else. When there is alcohol involved in the accident, there are laws in a few states that let the injured person seek compensation from a business or person who is known in the case as a third party. This third party would have had to provide alcohol to the individual who caused the accident. Claims filed against a business as known as dram shop laws. Social host liability and dram shop claims. Under Sections 11 to 100 and 11 to 101 of the New York General Obligations Law, social host liability and dram shop laws cover alcohol-related accidents. Section 11 to 100 details liability, and involves an intoxicated minor, whereas Section 11 to 101 details an individual or vendor who has provided the person with alcohol illegally. In cases such as these, someone who has been injured can bring a claim against the business or individual who provided the alcohol. They can only do this if the host or vendor knowingly caused the individual to become intoxicated or impaired by providing alcohol unlawfully. A claim can also be brought about if the host or vendor knowingly caused the individual to become intoxicated or impaired by providing alcohol unlawfully if they thought or were aware that the individual they were supplying the alcohol to was under the age of 21. In New York, if the intoxicated person was over the age of 21 and the alcohol was legally provided, the host or vendor cannot be found liable. This is the case even if the person who drank the alcohol caused a car accident and subsequently injured another person.